Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. The California Appellate Law Podcast is a resource for trial and appellate attorneys. Both Jeff and I are appellate specialists, but we split our practices about even between trial and appellate courts. My wife tells me that makes us attack librarians. So we try to bring that perspective and some legal news that our listeners will find useful in their legal practice.
And a quick thank you to our sponsor. Our podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse CaseText. Listeners of the podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
All right, Jeff, one of the topics that we discuss often on this podcast is the impact of that the COVID pandemic has had on legal culture. But I had noted recently a stat about the autism pandemic and how it now affects between 1 in 44 and 1 in 35 children by the age of 8 years old, according to a December 2021 Rutgers report. The autism rate in America has climbed some 241% since 2000. And one of the big ways that this affects the millions of families raising children with autism is in obtaining and fulfilling IEPs. That's an individualized education program. And so I thought it would be great to have a special education lawyer to come on the show and talk to our audience about these kinds of special education issues in the law. So today we welcome Tim Adams to the show. Tim Adams is an attorney focusing on education law and especially special education law and advocacy. He has served as an adjunct professor and associate director of the Special Education Advocacy Clinic at Pepperdine University School of Law. He's actively involved in educating parents and professionals in presentations and seminars. He's also trained Orange County Superior Court judges regarding special education law. He's been interviewed and quoted in publications including Daily Journal, Orange County Register, and the nationally published magazine Parenting. Tim is an ambassador for the Autism Community in Action, an organization that provides support for families living with autism, and he served as an auxiliary board member for the University of California Irvine Child Development School and was a founding board member of its successor, the Children's School. And in 2017, Tim co-founded Walls That Unite, a nonprofit organization that provides educational experiences in low-income communities in the United States and Mexico. Tim Adams, welcome to the podcast.
And thank you, Tim and Jeff, for having me today. It's a pleasure to be here.
Well, thank you again for being here and being willing to share your experiences. I wonder if you can tell us a little bit more about your practice than I covered in that brief introduction. What does a day in the life of a special education attorney look like?
Well, we spend quite a bit of time counseling families through the educational planning process. As attorneys, we're helping to, help them to navigate how to improve their educational programs or their child's educational programs. Those plans are created, as you mentioned at the beginning, via an Individualized Education Program, or an IEP, and that's set up through federal and state laws, and it's an obligation of the public school system, either the school district or a public charter school, to prepare that IEP. So often, when I spend my day speaking with parents about concerns that they have with those IEPs and how to resolve those concerns, whether it be a change in services or a change in goals. Most often it happens to be maybe a dispute over what's appropriate. And that becomes really the most important question in this field is, what is an appropriate education for students?
Maybe you can walk us through, when is the first time that a parent will likely hear the term IEP and learn about what this process looks like, and when do they first start to think, gosh, maybe I need Tim Adams or a special education attorney to help me enforce my rights under this IEP? How do they know if they're getting shortchanged or they're not getting all that the law requires that they get out of their IEPs?
Well, they may first hear that term depending on what their child's diagnosis is from, in California, the regional center system. So if we look in California has an obligation to address the needs of students that even before they reach school age. So from 0 to 3 years old, there are educational programs that are set up under Part C of the Individuals with Disabilities Education Act. That's the federal law that governs special education, and that provides a individual family services plan, or an IFSP, for students before they reach school age. And then that in California, the obligation to provide that program is through the regional center system. So they may discuss that with the regional center if their child is a student with an eligible developmental disability. If they're not, they may not hear that term until they reach school age and start kindergarten and realize my child's, delayed in some way or having trouble learning letters or reading. It could come as late as, in some cases, if it's maybe a mental health concern, junior high or high school, or could come as early as before they reach school age at 3 years old.
So some of these families have some inkling that their child has some problems, and they're getting their child assessed maybe even before they get into school, or at least before the school
Correct.
tells them about it.
That is correct. And so there's an obligation. It's a little complicated sometimes for parents to navigate, but they may be handed off from a regional center system to the school district. And there's an exchange that happens prior to age 3 where the school system takes over and has to assess and determine whether the child meets eligibility criteria under 13 categories, one of 13 categories or more than, one or more, and then makes that special education or IEP offer. And that's where the process starts. And that could start at any age. And in California, federal law sets the obligations of school districts between 3 and 20 and 21. California's extended that to 22.
Okay. Well, Jeff, do you want to ask a question?
Yeah. Hey, Tim, thanks again for being on the show. Sometimes I hear about the term advocate, that an advocate will attend meetings involving IEPs and special ed lawyers. What is an advocate, and what does an advocate do?
So an advocate could be just about anyone with specialized knowledge about the child. It could be a child's therapist. Maybe a child is receiving some services through a marriage and family therapist. It could be a relative, maybe an aunt, an uncle. It could be a doctor. It could be a child's teacher. Anyone who has specialized knowledge that is willing to advocate for the child's interests could be an advocate. And typically it's going to refer to as somebody who's not a lawyer, not a licensed attorney who's attending a meeting and advocating on behalf of that child.
Got it.
Yeah, I thought maybe let's pause this deep dive into special education law and back up for a moment. And Tim, tell us a little bit how you got into special education law. This is you're obviously deep in the weeds here. You know a lot about special education law. That's your specialty, and most of us attorneys don't know a lick about it. Maybe they don't even know. That's why I had to. I didn't stop with just the acronym IEP. I had to define what it is, because I suspect a lot of our listeners maybe have never heard that term or don't know what it means. Tell us how you got onto this. How you got into this specialty in the first place. Is this something that you started off with, or did you take a detour on a more typical?
That's a great question, and I really became exposed to the IEP process as a young child. I have a younger brother with special needs and relatives who were supporting him, including my mother, attending IEP meetings. And I spent my afternoons waiting often and doing my homework, waiting for my brother to finish therapies or tutoring, things like that. So I became exposed to the whole process as a child, although I didn't understand how the law would play into that. I just knew that mom was helping my brother out, and I was doing my best to give him a hand as well.
What was the system like at that time? Was your mom able to find support?
She was, surprisingly, at the time. My parents really had thought the answer was attending private schools and having him continue to go to one private school after the next. Unfortunately, those private schools weren't equipped. They weren't specialized special education equipped private schools. They were your run-of-the-mill private school, that maybe a parochial school that meant well, but really didn't know how to address his needs. So he had mostly learning disabilities and had some trouble with academic concepts, and did okay as long as he was in a small group or a one-to-one setting. So unfortunately, after moving through 2 or 3 private schools, they did find that the IEP process through the public school system was likely going to be the best match. And so thankfully they actually had a good outcome through the IEP process, and continue to have a pretty positive outcome. But my initial exposure, of course, to that whole process was as a child. And then moving into law school, I was looking for some elective courses to take, and disability law was an option. And I was at Pepperdine Law School, and it was an evening course, and it looked very interesting to me. So I signed up for the course and met a professor there, Dr. Meredith Gatz, who became a mentor to me. And she ran the special education legal clinic that at the time was under contract with the Lancherman Regional Center, and provided advocacy, free advocacy to families who had children who were consumers of that regional center. So my exposure was through a clinical program and that class at Pepperdine Law School way back in the late 90s, and ended up getting into this field as a result of that. Now, I'll pause for a second if you have any follow-up questions, but you know, a really quick follow-up. Did you have any questions about that, or, you know?
Well, just one. You had mentioned that that in your experience in your childhood with your brother having to go to deal with IEPs, and your mom navigating that process, you said that that fortunately it went fairly well. He seemed to get the services that he needed.
Correct.
So obviously you didn't need the future special education lawyer to come in and advocate for his rights. So did you have an inkling at the time you enrolled in Pepperdine Law School, or at the time taking this disability rights class, that I'm going to go into special education law, become an advocate for kids with special education needs?
I actually didn't. In fact, I didn't even know it existed until I went to law school. And I'd say most of my student colleagues, they weren't aware that this existed. And so of course, your average attorney doesn't know this exists. So, yeah, I did learn a lot about it, and then became very fascinated and very interested. Now, even though my brother didn't have any struggles, or at least that I knew of with through the IEP process, there were struggles in life, and there were advocacy moments that were, that presented themselves even after he finished school. So we were able to provide that support and assistance, because students that finish the IEP process and graduate still need to navigate their life, and their jobs and their higher education, and there are a lot of opportunities to continue that advocacy. So I would say for him in particular, that came after high school, once he received his diploma. But it was a revelation for me, having taken that class, that was really something that I was passionate about, was interested in. And after interacting with families and having the privilege of representing as an advocate under the supervision of two attorneys that were adjunct professors, several families that were had children consumers of the regional center, I really fell in love with this practice area.
Yeah.
And as a result of that, a friend of mine, a law student, was also in the clinic, drafted a business plan, and we proposed it to a mid-sized law firm right here in Orange County. And they agreed to take us on as, new graduates, developing a special education practice group. And that's how we got started.
Now, you had mentioned that even after your brother finished school successfully using the IEP process, that you spotted even afterward, there were, I think you call them advocacy moments, where maybe I wonder if you could unpack that a little bit. And
Sure.
Does that segue into are there counterpoints to you and your practice in the education realm, in the employment realm, where employment law attorneys need to be able to spot the kind of employees who may have these advocacy moments where they need someone to advocate for them in the workplace?
Yeah, and that's a great question. So these moments included interactions he may have with supervisors or other staff members, as he had a diagnosis at the time of ADHD, and so it sometimes is challenging for him to deal with stressful situations. And so there was a lot of counseling that took place, and in some cases behind the scenes, instruction. This is what you need to say to your boss or supervisor. This is what you shouldn't say. No, you shouldn't tell your boss to F off and walk out. That's not a good idea. Let's come up with some more productive ways to address the impulsivity and some of the anger issues that go along with the diagnosis. So, I mean, I was advocating not directly on his behalf in sort of a adversarial, sense, against an employer. It was more, it was a lot of counseling, I would say.
Yeah. Well, so when you graduated and passed the bar, did you go right into special education litigation and advocacy?
I did actually started, and through my mentor, Dr. Getz, we were able to, I started with several cases through the Lancherman Regional Center. They contracted with my very small office at the time, my office of one, myself, and we were able to represent, I was able to represent several families initially, and then ended up, I had a partner right after that. So we worked for a small firm. After I became a licensed attorney, I worked for myself, and then I partnered up and then developed a quite a robust practice. That partnership dissolved in around about 2009, and I've been on my own with associates since about that time.
Okay. Well, and let's try to put some more meat on the bones of what I think maybe for our listeners and for me, it might still be too abstract. So you're dealing with IEPs and advocacy. Now, does that translate into a lot of litigation, or is it a lot of paperwork, phone calls? What is a day in the life?
Okay, so it does translate into a lot of litigation, and this process starts always with an assessment. The first thing you have to do is assess a child to determine if they're eligible under several categories. I mentioned the 13 categories. As an example, a student with ADHD that and having that diagnosis doesn't in and of itself automatically qualify them for an IEP. If the ADHD doesn't adversely impact his access to education, then he could be fine without it. He may need something like what's called an accommodation plan under Section 504. I have some clients that just need accommodation plans under 504, but most of my clients have IEPs. So you start with that assessment. Is the student eligible, whether they have a diagnosis or not? You have a lot of families that don't have the resources to go out and hire doctors to get various diagnoses. So you may have quite a few undiagnosed conditions that manifest in the form of a disability that we haven't identified. Or maybe it's a really complex situation where you may never quite identify that disability, but you know that it's manifesting in negative ways that adversely impact access to education. They can't get up and go to school because they're really depressed. They're having trouble focusing. They maybe have limited vitality in some way. They can't stay at school for more than a couple of hours. We may not have identified that exact diagnosis, but it doesn't matter under the IDEA. As long as we can identify a category that would make them eligible for special education, we can call it, for example, an other health impairment or an OHI. If it's clearly a diagnosis that impacts, that's more academic in nature, impacts their ability to access their academic work, it could be a specific learning disability, an SLD. There are a lot of acronyms in this field. So I'll try my best not to use too many, but there's others. If the child has a diagnosis of autism, again, just in and of itself doesn't mean that they're eligible for an IEP. Maybe that autism diagnosis is not very impactful in the sense that it doesn't necessarily prevent them from accessing education or other services at school, and maybe it doesn't qualify for them. I'd say in many cases it does, but just because they have that diagnosis doesn't equal IEP eligibility. But there is a category under the law called autism, so there are many students that do qualify. So those are just three of the many. But once you reach that eligibility, then the next step is to develop to determine what the present levels of performance and functioning are, so we can develop goals. And those goals would be put into place in the areas of need that we've identified. So we're going to list all the areas of need, and then we're going to develop goals. And then those goals are going to drive where that student is ultimately placed, what school environment, looking at the least restrictive environment as the option. So we're looking at the neighborhood school with typically developing peers in a regular classroom with some supports, maybe some accommodations. Maybe he sits in the front of the class, so maybe he has an FM system, he has trouble paying attention, things like that.
I have a question in mind. I wonder if you're leading up to it. Is
sure.
What is the source of the disputes? By the time they get to you, obviously, the parent has probably had the conversation about developing the IEP, and is the school telling them nuts to you, I'm not doing the IEP, or is it just you don't qualify, or I'm going to give you ABC but not XYZ, and that's where the dispute is? Why are they coming to you as a special education attorney?
All the above. So what you just mentioned, all of those reasons are reasons why parents may come to my office saying, I strongly believe that my child qualifies for an IEP. He's struggling, he's failing classes, but the district says he can do it. He's capable, he's choosing not to, therefore we're not going to qualify and we're not going to provide the supports. There are circumstances where they're already eligible, and we have a dispute over the amount of service, the intensity, the methodology, all sorts of disputes. When we have a child with dyslexia, for example, where the district feels strongly that they have the appropriate structured environment to provide support and ensure that child's success, and the parent says, no, class is too big. They're using the wrong methodology. The teachers aren't appropriately trained, and therefore he continues to fall behind. He's in 5th grade, but he's at a 2nd grade level. I get those clients frequently, and then we're looking at private placements that specialize in providing instruction to students with dyslexia. So, and we also have, a number of other types of disputes. I have a number of students, unfortunately, post-COVID that are, their mental health conditions have worsened pretty significantly. And so, unfortunately, we're placing a record number of kids through public school districts and negotiations with them in residential treatment facilities or therapeutic boarding schools, 24-hour care facilities.
You say a record number. What does the uptick look like in terms of percentage increase?
I'd see a 30% at least increase in the number of students that are, at least that I'm serving, that are being placed. And these are new clients and existing clients that aren't being supported, in a day program in their neighborhood school, or even in their specialized private school. And as a result of that, we're having to look at alternative options that are more intense therapeutically, and often out-of-state programs.
So this uptick that you mentioned, some 30% since before the pandemic started. These are going to, you said, residential treatment facilities. Excuse me. What is the nature of the treatment that they require?
So it's really they're receiving their education typically in a normal school day, but it's essentially a boarding school, and they're also receiving a lot of therapy throughout the day through a number of professionals. In some cases, medication management is also on site. Depending on the severity of the disability and the need, you may have less restrictive therapeutic boarding schools and more restrictive therapeutic boarding schools. And California's rules are a bit different than some out-of-state programs, but California school districts contract with dozens of out-of-state residential facilities to care for students with mental health challenges of various sorts. So I'd say the vast majority of my clients that receive residential care, on an IEP are out-of-state, meaning they're receiving services out-of-state, but they're residents in California.
Interesting. Hey, on the subject of an IEP, let's say the parents agree on the goals and agree on the services, and everybody's in agreement, but the school's just not meeting those services, not following the IEP. What remedies does a parent have to enforce an IEP short of litigation? Is there anything a parent can do to force a school to follow the IEP?
Yeah, absolutely. That's actually a fairly streamlined approach. And I had a client email me about that just this morning. If you believe that the school district is not in compliance with the IEP, and it's very clear that the IEP requires certain items, implementing a service or a goal or an accommodation that's not being done, you have the option to not litigate, but file a compliance complaint with the California Department of Education. There's a very easy form to fill out on the California Department of Education website in their special education division. And there's a 60-day timeline once you complete that form and submit it, usually with some exhibits, some evidence of what's supposed to be happening that's not. And they will complete their investigation within 60 days and make a decision as to whether the district is in or not in compliance.
And does a parent need a lawyer to initiate that kind of process?
They do not. They do not need a lawyer. In fact, even though lawyers can initiate the process for them, and there's the availability of attorney's fees if you are the prevailing party, if the lawyer does it, the parent, and that's what's helpful for this in general. If you litigate or you file a compliance complaint, if you're the prevailing party, you can pursue collection of attorney's fees. The parent doesn't have to use a lawyer. They can fill out that form themselves. They can mail it off, fax it off, email it off, and the investigation will be completed and decision rendered within that 60-day time frame.
And in your experience, does the state rubber stamp what the districts are doing, or does this result in actual enforcement of IEPs?
It does actually. So what's interesting is the administrative court, and we haven't gotten to that, Jeff and Tim, but if you have a dispute, you have to exhaust administrative remedies by filing a special education due process complaint. And in California, the agency with the current contract is called the Office of Administrative Hearings. Their special education division handles those complaints. You've got to go through that process first. So with respect to that, the parent would initially, if it wasn't a very clear-cut compliance issue, they would usually have to go through that litigation process. And then, they'd have to go through an administrative trial, a due process hearing, get a decision back. But with the compliance complaint, they submit it, they wait for a decision. And I would say, in our experience, most of the time, if it's clear cut, meaning the district was supposed to provide 5 hours a week of speech therapy and they provided 3, and the district can't prove they provided 5, then the parent wins. It's really not, if it's a little murky or there's any subjectivity to it, it probably shouldn't be filed as part of a compliance complaint. It needs to be really clear cut. And so in answer to your question, the short answer is they do a pretty good job if it's a really clear cut issue.
Got it. Interesting.
All right. Well, Tim, you said that in advocating for IEPs, you've had to file a lot of due process complaints.
Correct.
And that quite a bit of your work is litigation. Why does litigation become necessary in so many complaints? Isn't this supposed to be non-adversarial? Aren't these families who are dealing with special education issues under enough strain as it is without having to go through litigation?
It is supposed to be, but unfortunately, cost considerations are pretty significant for school districts. Parents are often having, as a result of their child's needs, to ask for more money than the district receives from the state, and that the state receives from the federal government to fund special education programs. So you may have a district that receives, $15,000 to pay for all the services for a child, but their program costs, $100,000. So that's really the motivator for the litigation, is they're trying to save cost in our experience. Now, the law doesn't really heavily consider that cost factor in decision making, so it can't come up, or it shouldn't come up in the IEP discussion. They can't say, oh, it's too expensive, therefore we're not going to provide it. But in reality, it's always a consideration. The district's weighing how much is it going to cost to pay for this program versus litigate. Can we win? They're looking at their exposure and trying to make some decisions. And unfortunately, for parents, it can be a lengthy and time-consuming and sometimes expensive process if they have to litigate. But it's necessary if they really want to get that program that's appropriate for their child in place.
That's interesting. You mentioned that that cost is what, not a legal consideration. It's not recognized as one of the considerations, even though it's the elephant in the room that no one can talk about.
Under a case called Rachel Holland, it's very low on the totem pole, but it doesn't really come up, and it shouldn't come up in an IEP discussion if it's what the child needs to get an appropriate education. Yeah.
So it's not the school's ultimate responsibility in the eyes of the law to make the numbers foot. They just they have to, if the child is deserving of the program, the school is obligated to give it to them.
So the law, and I'll paraphrase, requires a program that's reasonably calculated to confer an educational benefit to a student based on that student's unique circumstances, and that program has to be appropriately ambitious. Okay, so these are That's how we interpret what the law, the Individuals with Disabilities Education Act, calls a free, appropriate public education, or FAPE. So that's how we define it. But as I'm sure you've heard from that description, that's kind of subjective. Like, how do we, what does that mean? So what we have to do, Jeff and Tim, in this process is we have to get independent evaluators, experts, to help us define and design the program for these students. So we typically will have the district start with their assessment. And if we don't agree with the outcome, then we'll ask for an independent evaluation of public expense, an independent educational evaluation, an IEE for short. And the district can, we can ask the district to pay for it. They have two options. They can either fund the assessment by the qualified person that my clients would choose, the parent chooses, or they can file a due process complaint to defend their testing. But that independent evaluation is really going to drive what happens next. That expert's going to tell us what's wrong with the district's program. Can it be fixed? And if it can't be fixed, what should this student receive in terms of an appropriate program? Is it a smaller class size? Is it a different methodology? Is it a new accommodation? Or is it a completely different school? It could be a completely different school, and usually that school is not going to be in the district. It's going to be a private, what's called a non-public school. In some cases, and in other cases, it may be a private, non-certified school. In California, we have this unique requirement that schools that contract with school districts for special education have to be certified as an NPS or an NPA, non-public school or non-public agency.
About how many of these lawsuits do the parents win, and how many do the schools successfully defend?
Unfortunately, parents don't win a lot, and parents are not often represented by counsel. They're representing themselves. Sometimes they don't, parents are, scared to show up to the hearing. They may not show up. So parents win fewer cases, especially the ones that are unrepresented. I don't have the exact statistic as of right this second, but it's less than 50% for sure.
But you did mention that the prevailing plaintiffs in these cases may be entitled to attorney's fees if they win?
That is correct. So we call them petitioners, at least at the administrative level. So you have to start with the due process complaint filed with the California Office of Administrative Hearings. That's the current agency that is under contract to decide these claims. And then, once you get a decision in favor, if you're the prevailing party on an issue of significance that materially changes the position of the district as to the parent, then you're deemed the prevailing party under the law, and you can ask for reasonable attorney's fees. Now, what we consider reasonable, what the school district considers reasonable, there's a completely different opinion every time. So we may send a bill and they go, we only want to pay a third of that, because you won 1 out of 3 issues. But the law doesn't really proportionalize it. It doesn't say you've got to win, assign a percentage based on the number of issues you win. It's just an issue of significance. So you could win 1 out of 10, and that one issue could be worth a huge amount of money to or a great program to the family, and that could be an issue of significance enough in order to collect attorney's fees. But that does drive the parent's ability to obtain competent counsel to represent them through the process, because attorneys, they either can represent on a fee deferred basis, or they can significantly discount their fees in order to take cases to hearing.
And how far up do these cases wind up getting appealed often? Do they get appealed to the district court or then to the court of appeals? Or they would typically be state court, I assume?
No, actually, we spend most of our time in federal courts. I'm rarely in state courts. I think that, it's a federal law, and it's very clear that they have jurisdiction to hear these claims. And so we typically would file an action, or the other side, the district would file an action for appeal in a federal court. What's interesting about the attorney's fees provision, so administrative law judge really doesn't have jurisdiction to make attorney's fees decisions. There are some, I've heard colleagues discuss, if there's a stipulation, maybe the judge would make the decision on fees, but I wouldn't necessarily be comfortable with allowing the administrative law judge to do that. So I typically get a decision, and if it's in our favor and we're the prevailing party, I'll send a demand for fees and give the district a period of time to respond. If they don't respond, then I'll file a separate action in federal court to collect fees. Now, on the appeal side, again, most of them, almost all of them in our office are going to the U.S. District Courts, whether, depending on where we started the case, either Southern, Central, Eastern, or Northern. Vast majority of our cases are going to be in Central and then a couple in Southern. We've had a couple in Eastern in the past as well, but and then beyond that, they're up to the Ninth Circuit Court of Appeals. And I've had several of those over the years. And then a couple that we petitioned for cert to the U.S. Supreme Court. So they go all the way up.
Yeah. Now back up a moment to the process for how the administration of services works. One of the reports that I've been hearing a lot over the last couple of years is a lot of kids, a lot of families pulling out of their local neighborhood public schools and enrolling in either homeschooling or putting them in private schools. They might be outside of a charter. If for families who do that, who are not either under a public school or under a public charter, do they disqualify themselves for IEPs and provisions of public funds for their support, or do they still qualify?
So they still qualify for support, but it's the family does have to reach out to the public charter school or the school district that they're enrolled in. Typically, it's a school district. If you are attending a private school and you feel like your child may be eligible for special education or needs services, then the first thing you do is to send a letter to the district or your neighborhood school saying, I'd like my child to be assessed, special education assessment, to determine if they need an IEP. The district would then have an obligation to provide an assessment plan or a consent form within 15 days. The parent signs that, returns that. The district then has 60 days to complete the assessment process and hold an IEP. So if your question is, if they've already got that and they leave, are they entitled to services? They are, and our position is that they are, as long as they maintain active contact with the school district and make it clear that they have a dispute over the IEP. They file a due process complaint to adjudicate that, and that they continue to hold IEP meetings based on a recent Ninth Circuit decision called SWBW, or Capistrano versus SWBW. They have to, according to that panel, and I don't necessarily agree, but the parent has to continue to ask the school district for IEPs. And normally speaking, if the parent resides in the district, the school district has an obligation to continue to hold IEPs. And I think it's clear based on that panel's decision that family in particular, and I know that case pretty well, it was my case. Unfortunately, the panel saw that they had sent an email at one point saying they were going to go private for 2 years. And that panel thought that was notice enough that they were off the grid, so to speak, for 2 years. So our position is that as long as you tell the district that you're interested in having IEPs, they have an ongoing obligation to continue to hold those IEPs. Okay,
so that's an important decision to be aware of. We should cite that in the show notes. We'll get that citation from
sure. Yeah.
Well, let's talk a little bit bigger picture about the problem generally, and maybe how the legal system and lawyers can come to the rescue. Is there something more that attorneys should know about the process so that they can help? They're probably a resource to their loved ones, people in their family. Probably going to say, I'm going to talk to my the attorney in my family about what we should do about getting little Johnny the services he needs. What does the family attorney need to know to steer their loved ones in the right direction?
So they would certainly want to start by reaching out to their public school district and asking for the public school district to complete an assessment if there's any suspicion whatsoever that there's a special education need, whether it's a diagnosis or not. If we suspect that a student it has a delay with speech, or is having some struggles in school if they're school age. If they're not school age, you would reach out to the regional center. But the best first step is to contact your neighborhood public school and say, I've got a child who's struggling in this area. How can you help? And they have an obligation to provide you with a list of supports and services, what's called procedural safeguards. Certainly a parent can get on Google and do Google search for special education attorneys. We consult with lots and lots of families who don't become our clients and give them direction depending on their circumstance. But I would say start with the internet's a really good resource, and going through the California Department of Education, going through the County Department of Education, and looking for special education resources. But if there's any suspicion that a child is struggling, we'd start with that assessment.
Yeah. Well, and you mentioned a lot of these civil rights lawsuits, are improper. A lot of the families do not get legal counsel. Is that a mistake? Should they be contacting you or another special education attorney?
Well, when I say proper, it's at the administrative level. Typically, a parent cannot represent their child in a court system, right? A U.S. District Court, appeals court. They would be required by the court to retain counsel. If they're representing themselves, that's okay. But if they're representing their child's interest, they would have to have counsel. But yeah, with the Office of Administrative Hearings, the administrative level, they don't often have counsel. And even if they didn't have an attorney, I always strongly recommend parents that parents talk to an attorney about the process and see if there's a way to come to find some resources. There are some resources available sometimes through the regional center system, through some nonprofits. Unfortunately, there's not a lot of them, but they are available. And in fact, the Office of Administrative Hearings, the agency that hears these claims, maintains a list of free and reduced priced attorneys. And we do take a fair number of cases that are fee deferred and discounted. All our cases are discounted, but fee deferred, depending on, the number of cases we're handling at the time.
Yeah.
Hey, does the hearing officer who hears these cases, does that hearing officer only hear these types of cases, or are they hearing all sorts of different administrative law issues?
And typically, if they're full-time employed by the special education division of the Office of Administrative Hearings, they will only hear special education cases. There are times where they'll pull somebody from their general jurisdiction who is hearing, last week heard a licensing case, and this week's going to do special ed if they're short staffed. But in my experience, it's usually just full-timers that hear special ed claims all the time.
Do you want to tell our audience a little bit about the Lanneman Act? I understand that's the law that requires I think it's the regional centers, maybe it's the regional centers that we talked about for disabilities and advocacy for people with disabilities. Is that Lanneman Act to help? Does it do enough? What are the gaps that need to be filled in this space?
What's interesting is Lanneman Act in California, the regional center system wears two hats. Okay, so I mentioned the Part C of the IDA is the early intervention program component. So students that are kids that are 0 to 3, so birth to 3, they still may have needs that the school district isn't responsible to address. So in California, we've assigned the responsibility to be the educator to the regional center system. And so the regional center system also has the responsibility to take care of people that have qualifying disabilities under the Lanterman Act. So they're wearing two hats. They've got the early intervention unit that is the educational provider. That's the regional center under the and then you've got the regional center also carrying the responsibility of addressing the needs of people with developmental disabilities, that once you become eligible for the regional center as a person with a developmental disability, then you receive certain benefits and services for life. Now, the Lanterman Act is unfortunately, the requirements that the regional centers are supposed to have has watered down over the years. Since I first got into this practice in the early 2000s, Lanterman Act used to require quite a bit more from the regional center system. They are the payer of last resort in most cases, in almost every case. And so if the school district or if another state agency does not have to provide a service or a program, the Lanterman Act says the regional center has to pick up the tab if it's necessary for their consumer. Now, that's only people that are still eligible once they've turned 3. Because remember, you've got this group of 0 to 3. Some of those people may not be eligible once they reach school age under Lanterman Act conditions, but the regional center is still responsible under Part C of the IDA. So you have the shift where some people will remain eligible and receive school age services as a consumer for life, and other folks will transition to the school district, and the school district is then responsible, but they're no longer receiving services from the regional center because they do not qualify under the Lanterman Act. So depending on the severity of their developmental disability and the permanency of that developmental disability, the Lanterman Act would require that the regional center continue to maintain programming services, but only as the payer of last resort after age 3. I hope that wasn't too confusing. There's a lot of moving parts there.
Well, yeah, there's a lot of moving parts in this whole space. So let me ask you this. It was one of my last questions about, as a special education attorney, what spaces are you watching in the judiciary when cases come up on these issues? What questions are left unanswered? What spaces are you watching in the area of special education law?
Well, I'm curious to know on the funding issue, and this is one that's going to come up. And I when Congress gets around to reauthorizing the IDA, can I start with that? I'd like to know if at some point parents are going to we're going to write into the IDA that expert witness fees are also recoverable, because that becomes a significant expense. And so
are experts often used in these administrative hearings as well?
Absolutely. Expert fees can be very expensive. So even though attorney's fees are recoverable, expert witness fees are not recoverable. It's not clear, and courts will not allow that. The IDA doesn't specifically state they're recoverable. So ultimately,
so it's not known. Do some courts award those expert costs?
They're clearly not recoverable. So
they're not recoverable.
So they're not recoverable. Yes. So because of that, we'd love to see a shift in terms of, I would love to see some of the other circuits, make some clear decisions on parent districts' ongoing obligations on students that are privately placed, and parents' rights when those students are privately placed. Does the student and the parent have an affirmative obligation to reach out to the school district and start that process and continue that process and continue to engage the school district in discussion? Or is it the school district, the government agency that obviously has more resources and more knowledge, that should continue to be responsible to help and guide the parent through that process? Because the concern I have, and I'll go back to the Capistrano versus SWBW decision, is that puts a lot of burden on parents to continue to have to even know that they would continue to have to reach out to the school district and ask for help. Little do they know, if they don't, according to that panel, they may be losing all sorts of potential reimbursement, and the district may not have ongoing responsibilities unless they continue to engage. So I'd love to see more circuits make some clearer decisions, and I'd like to see a case up. Unfortunately, our case on the SWBW case, the petition for cert was denied. So I'd love to see the Supreme Court take that type of case and make it really clear that it's always the school district's obligation to affirmatively reach out to parents and continue to hold IEPs every year, unless the parent clearly waives their right to have that IEP.
Yeah, I wonder if you advise clients to send out Capistrano notices, every semester to the district.
Well, I'll put it this way. Yeah, exactly. I put it this way. I tell parents that talk to me, in fact, most of our letters will always say parents continue to have an ongoing desire to work with the district to hold IEPs. We make it very clear in almost every piece of correspondence that we're not waiving our right to request an IEP. Yes, we may be actively disputing an IEP. We may be privately placed, but we're not waiving our right, and we continue to request that IEP meeting. Again, that panel, I think, got it wrong. And I'm Supreme Court didn't want to hear it this time, but maybe at some point in the future, we can convince them to hear it on a different case.
Yeah. Well, and you mentioned expert witness fees really need to be compensable to the prevailing students.
That's a congressional thing. We got to, Congress is going to have to fix that, but Congress seems to be too busy to worry about special ed. Unfortunately, it's an important issue, and they haven't gotten around to it since 2004. That was the last time the IDA was reauthorized and went into effect in 2005.
Interesting. Hey, in terms of the future and clients that are coming in to see you, have you encountered parents that are seeking accommodations or IEPs for their children who are suffering from long COVID? Or do you expect that to be a part of your practice going forward?
I haven't, at least it's not clear. I do have some unique medical conditions that I've seen recently, but that, as far as we know, they're not COVID related. Most of my clients, children we've seen, I think in general, have been pretty resilient to COVID. I think it's the adults that have had more trouble, right? So the ones with pre-existing conditions, especially, and the older adults. So I really haven't, the part about COVID that was really unfortunately very negatively impactful for my clients was the way that California, treated really, that dealt with the circumstance of closing schools for such a lengthy period of time and leaving it up to the school districts to decide in some cases when to reopen. We had situations where school districts didn't reopen for over a year. So they closed effective, say, the first, mid part of March, and they didn't reopen in some cases until April or May of the following year. And that's too long for kids to be out of school. So if you're talking about the COVID impact, it's not the illness itself, that it was the reaction to the illness that really caused the most significant harm to students, in my opinion. And as a result of that lengthy school closure, we've got kids that were already really far behind that are much further behind. Most parents didn't realize, but school was optional in the spring of 2020 through the end of the school year. Parents didn't have to send their kids to school, kids didn't have to go, and teachers didn't have to show up to work.
Hey, does that mean that districts were off the hook in terms of their IEP obligations to families during that same time period?
And that's a great question. The answer is no. And Congress actually asked the U.S. Department of Education Secretary Betsy DeVos to weigh in on that when they passed the CARES Act, and gave the U.S. Department of Education about a month to respond. And the Secretary very clearly stated that the obligations continued. There was no, and there should be no waiver. At least that was her advice to Congress. Congress didn't take any action to change anything. So, but yes, districts were lobbying. They shouldn't have to continue to implement IEPs during the COVID closures. And the Secretary said, nope, you need to continue to implement these IEPs. The timelines remain in effect. In fact, if anything, the kids that were early intervention that were this, before the school age, 0 to 3 kids should probably get some more funding, because they missed out. Unfortunately, they didn't get that transition from the early intervention program to the school district. So if they got caught, if they turned 3 in March of, or April of 2020, there was no school to pick up, the program for them. And they could have really been struggling. So you've got a lot of really young kids that were kind of left out in the cold, and school districts throwing up their hands going, well, we're closed and we're not going to take any action until we get back to school in person. But that's where a lot of our cases are stemming from, and now we'll continue to see litigation and more litigation through the appeals process, probably for the next decade, as a result of COVID closures.
Interesting.
All right. Well, as we wrap up here, Tim Adams, what are your predictions and prescriptions for the future in this space? You see things continuing to get worse, and we're going to see more problems. You mentioned the 30% uptick in kids needing these residential services, additional services. Are we going to see funding? Are we going to see new programs for these things? Or are we just in for a lot of unknowns?
Yeah, I don't know. It depends on who the next administration is, and with respect to funding. Funding has been an ongoing discussion. Again, the federal government has never fully funded the IDA, so states are often left to decide how to close, to bridge the gap between what they get and what they need in order to pay for students' education. In terms of the result, I'm going back to my, what we saw as a result of the COVID closure. I mean, my prediction is that we'll continue to see a lot of significant struggles. It's going to take us several more years to recover from those closures. And as a result of that, we're going to see a lot more kids on IEPs. We're going to see a significant increase in kids with mental health conditions that require treatment, a lot more anxiety related issues that we're going to see that I haven't seen in my career. I've never seen so many anxious kids that are in need of counseling, support, therapy, medication, and placement in mental health treatment facilities. So my prediction is that, we'll just see an increase in the number of IEPs that are needed to address mental health concerns.
Yeah. All right, Tim Adams, we want to thank you again for coming on the podcast and keeping our audience abreast of these issues. It's a very important area that affects a lot of people and a growing number of people. Please keep us updated on on more cases and developments that come up in this space, and look forward to having you on to keep us updated in the future.
Excellent, Tim and Jeff, and I appreciate you having me on. It was a pleasure to speak with you both today.
Thank you. All right. Well, that wraps up this episode. Again, we want to thank Casetext once more for sponsoring the podcast. Each week, when we include links to the cases we discuss, we use Casetext for the case database, and listeners of the podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
And if you have suggestions for future episodes, or if you're a member of Congress that wants to weigh in on the recoverability of expert fees in these types of special ed cases, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
All right, thanks. See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.